The most common mistakes that we see with estate planning are number one, not having an estate plan. Not having an estate plan, you are literally putting all of your assets into the hand of the government. And the government is going to say what happens to your assets after you're gone. The state, the statute, and the judge. That's who decides what happens to your assets. So that's the number one biggest mistake. Number two biggest mistake, waiting too long. I'm 38 years old. I'm not gonna die anytime soon. I don't need an estate plan anytime soon. You're wrong. People pass away all the time from cancer, from heart attacks, from car accidents. Your age at the end of the day is only a number. We all pass away. We don't know when or how. Do not push this off till your 60s or your 70s thinking that you're going to live a long life, because that's simply not the case for everybody. So, mistake number two, waiting too long. Go ahead, button this up, get your estate plan, remember your umbrella, and it never rains when you remember your umbrella. Number three, not naming guardians when you have minor children. Our children are our most important assets. So again, when we have minor children, it is the most important time to create an estate plan. I have lots of clients that come to me in their 60s and their 70s and their 80s, but at the end of the day, it's my generation. It's my age group that has minor kids, young kids, that we have got to say what happens to them in the event that something happens to you and your spouse. Especially if you're a single parent, we've got to make sure that your kids are going to end up with who you want your kids to end up with. Number four, thinking that a will is all you need. You don't just need a will. You need incapacity documents. What happens if you're alive but incapacitated? Wills have nothing to do with that. Vice versa, thinking a power of attorney is going to do anything after you've passed away. Power of attorneys lose all power after you've passed away. So you have to have both. You have to have your power of attorney documents, incapacity documents, and then you have to have your will. But also thinking that a will avoids probate court, it does not. Only a revocable living trust or beneficiary designations can do that. However, in Georgia, if you own property, you need that living trust. And whatever you do, please, mistake number five, do not add your children to your accounts or your property deed. This is a really bad idea. Number one, it's going to cause big capital gains tax consequences on the back end. Number two, if you have a falling out with your child, which people say, oh, that would never happen. I see it happen all the time. Good luck getting them off your deed or your bank account, because they have to sign off on it and they're not going to do that. And then number three, if they ever get a divorce or file for bankruptcy, all of your assets are now liable for their debt. So it is very important to realize that number one, you need an estate plan. You need it today. You need to protect your minor kids. You need to make sure that you have more than just a will. And you need to make sure that you're not adding your children to your deeds or your bank accounts, because that is creating liability and tax consequences.